Professor Crouch is an associate professor of law at the University of Missouri School of Law. And before entering the academy, he was a patent attorney at a law firm in Chicago. Dr. Rafatijo is a student that is studying with Professor Crouch. And so their paper deals with one of the cases that we've discussed a decent amount today, Allen v. Cooper, and the implications. You can see a full copy of their paper, symposium.byu.edu, if you click on the schedule and get to this session. And I know that they are eagerly interested in hearing feedback from this audience as they finalize their paper in preparation for publication. So with that, I'll turn the time over to our presenters. Thanks so much.
Hey, great. Thanks so much, Peter, for having us here today and the organizers. It's been a really wonderful event. I hope that we won't let you down, and I don't think we will. I really enjoyed Professor Smith's presentation. And, you know, Black Lives Matter, it's interesting, right, from the IP perspective, because really it's this decentralized public social movement. But property rights, including IP rights, they're designed around private rights. And so they tend to, right, it's always a tough fit. And for me, her talk also highlights this ongoing tension with trademark law, that you're not really tying trademarks to the creation of this, this creative work, but instead to the use in commerce and to the perception of the public. And all of that makes those issues pretty tricky. But hopefully we can have a trademark and intellectual property regime that is at least supportive of powerful social movements and not taking away from them. Now, I was looking at the names of some of the attendees today. I'm super glad to see many of you again here today. As Peter suggested, our article is very much a work in progress. We're planning to publish it this fall. It's up on the symposium website, and we would love to have questions here today and suggestions during the session, as well as afterwards. Feel free to email us, etc. My co-author, as Peter suggested, is Dr. Homayoun Rafatijo. He's been a chemistry professor, but decided to head back to law school and is about to graduate this semester. And I've had just so much fun working with Homayoun over the past few years as a student and really as a colleague. And we've worked on a bunch of projects together and it's been a lot of fun. This particular project is really Homayoun's brainchild. And he did the lion's share of the work. But I think I contributed at least a little bit. And so I'm really happy to be here with him today. The focus here is on immunity of the individual states in the United States, the immunity from being sued in federal courts. And in 2020, Supreme Court decided Allen v. Cooper. And in that decision, they rejected a congressional statute that stated that says that states can be held liable for copyright infringement. And instead, the Supreme Court found that the US Constitution protects states' sovereign immunity from being sued for copyright infringement. In our paper, we argue for a few different reasons that Allen was wrongly decided. I'm going to pass the mic to Homayoun to get started in terms of the work that we've done.
Thank you, Dennis, and hello, everybody. My name is Homayoun, and I have a pleasure to be with you guys today. So to set the stage, I need to give you a little bit of a background why Allen became Allen. Well, in 1985, the Supreme Court laid down a test in a Atascadero State Hospital case that Congress can abrogate sovereign immunity for states so long as it makes its intention expressly clear. Now, this holding was reaffirmed a few times, but most notably in Union Gas, the court said, well, so long as Congress makes its intention clear, then Congress has the authority under Commerce Clause to abrogate sovereign immunity. Now, the Congress in 1990 and 1992 enacted two statutes, abrogated sovereign immunity for patent cases, patent infringement cases, and the copyright cases. Now, after Congress enacted those statutes, a few years later in Seminole Tribe, the court basically overruled the Union Gas decision and said, like, the Article 1 cannot be used to circumvent the sovereign immunity. Now, although the court acknowledged the fact that in some cases there might be a valid 14th Amendment argument, but certainly Article 1 is not a basis for abrogation. 3 years after Seminole Tribe, a patent case went up to the Supreme Court. A Florida state entity was accused of infringing a patent owned by College Savings Bank. The court cited the precedent in Seminole Tribe and says Article 1 cannot be used, although the court said again, repeated itself that there might be some 14th Amendment argument, but that's the case only if Congress had identified a clear pattern of infringement. And because Congress did not do so, therefore, the case was dismissed. Now, the copyright counterpart of the patent case went up to the Supreme Court between a North Carolina citizen, Allen, and the state of North Carolina and some state officials. And the dispute raised out of Allen's claims of state officials publishing his photography, media on websites. Now, the court again cited the precedent here, Florida prepaid and said, well, if not the patent, not the copyright for the same reasons. Now, the Allen case is very, very important for copyright owners because effectively the Allen foreclosed the possibility of copyright owners seek damage remedy in federal courts. Now, copyright owners will have three possibilities ahead of them. They have to go to the state courts. Well, the state courts might not consent to the suit. And according to another Supreme Court sovereign immunity case, well, they are immune in their own against private suits in their own courts. Now, even if the state courts provide cause of actions for copyright infringement and consent to the suit, most of the cases, most of the time we see that the case is dismissed because of the preemption of the federal copyright laws. And in a recent case from a state of Texas, we see that sometimes, even if there is a cause of action other than the state copyright cause of action, the court will dismiss the case just because the court see copyright as a non-untangible property which cannot be taken. So infringement basically is not taking per se. So the whole thing is very important for copyright owners. Basically, their rights are chipped away. Now, we argue that the Allen's wrongly decided for particularly 4 reasons. Number one, we argue that the notion that 11th Amendment embodies a broader sovereign immunity doctrine is wrong. Number 2, we argue, even if the court is right on the first prong of our argument, but the algorithm that the courts press forward, if patent then copyright and vice versa, is not consistent with historical evidence. Number 3, we assuming courts right on the first 2 prongs of our test, we believe under the 14th Amendment argument here was supported by sufficient congressional record, and the court cannot evaluate congressional record denoble. This is barred by the Constitution, as we understand it. Now, the last thing we want to mention is that the court coached its decision in terms of stare decisis, but the underlying to just promote or advance some agendas that each member of the court was pursuing by this decision. Now let's study the first of these reasons. So according to the court, sovereign immunity has 2 branches. one branch that is expressly stated, articulated, or formulated in the constitutions is 11th Amendment immunity. And it's clear, limiting the subject matter jurisdiction of the federal courts only when there are certain plaintiffs involved and the defendant is the state. Now, the basis of the jurisdiction must be diversity. If a suit comes within the scope of the 11th Amendment, then the 11th Amendment immunity applies. Now, to be clear, here in Allen, we don't have the 11th Amendment immunity because there is no diversity jurisdiction. Allen, as I mentioned earlier, was a citizen of North Carolina. So there's no diversity jurisdiction, no 11th Amendment immunity. And other types of immunity that courts often talk about, and recently Justice Gorsuch called it structural immunity, is a broader concept of immunity that is implicit in the Constitution. So to be clear, every member of the Supreme Court agreed to the fact that this immunity is implicit in the Constitution, but it is not expressly stated in the Constitutions. Now, with regard to the 11th Amendment immunity, there is no debate that it was decided, it was ratified in a narrow scope, and that only applies to diversity jurisdiction. There are a lot of historical facts to it. We just briefly explain, we briefly go through the timelines. Well, after ratification of the constitutions and ratification of the Article 3, the Article 3 gives the Supreme Court the power to decide cases based on the federal question and also diversity jurisdictions. Now, the federal question part here are highlighted by the text in yellow, and the diversity jurisdiction part is the text in purple. Now, in 1789, the first Judiciary Act passed by the Congress only gave the court, granted the court the diversity jurisdictions. As you see, there is no yellow text in the Act of 1789. Now then, 4 years later, the famous case of Chisholm was decided, where a non-citizen of Georgia sued Georgia for money damages, and the court basically rejected the sovereign immunity defense. A couple of years later, in response to Chisholm, both bodies of the Congress come up with resolution, and specifically here the resolution proposed by the House is very important because the House resolutions had statements going toward both federal question jurisdiction and subject matter jurisdictions. However, the 11th Amendment, as it was ratified, dropped the federal questions jurisdiction part of the resolution and only adopted the diversity jurisdiction. So, and as I said earlier, there's no dispute that 11th Amendment, as it is formulated as or read into the constitutions, involves only cases that comes from the diversity jurisdiction of the court. Now, when it comes to the structural immunity that Justice Gorsuch is talking about, it's very important to realize what is the operative legal framework at the time that the Constitution was ratified, because this structural immunity doesn't come from the text of the 11th Amendment. Now, there are some people who argue that it has a common law basis. Well, and that the structural immunity pre-existed the constitutions. This is correct to the extent that sovereign immunity for the states was articulated in the Articles of Confederation. But before that, American colonies were not sovereign states because the term under the British law was only defined for the Queen or the King. Now, even if we assume the common, there is some common law rules for sovereign immunity, this structural immunity, well, because it was not read into the Constitution, then it remains common law, and much like all other common law rights, it's a divisible power, can be abrogated by statute. So those who think the sovereign immunity or the structural immunity is a common law right, well, it is abrogable by the statute. Other people, like other scholars like Professor Nelson, believes that it's a personal jurisdiction type of thing, this structural immunity, that the sovereign could not be sued for a practical reason, that nobody can force the sovereign to come to this court by civil process, and therefore no case or controversy will attach, no Article 3 judicial power will extend to it. But if even Professor Nelson explained this in details, that even if we assume that's a personal jurisdiction theory, the Congress could modify the principles of the general law to form or restrict the case or controversy. So basically, the Congress can attach personal jurisdictions, and there is a great discussion in Professor Nelson's paper that particularly Congress can use Article 1 proper necessary clause to do so. Now, what we are more inclined to accept is a natural law theory of structural immunity. And if you review most of the statements made by the framers, both at the time of the convention and after that, the framer seems to adopt the natural law theory of sovereign immunity. Now, the famous one comes from Alexander Hamilton, which refers to it is inherent in the nature of sovereignty, so indicating that it's a natural law theory. Then by Chief Justice Marshall, which and his position culminated in a Cohen case. Well, he said that any cases that rise under the Constitution and the federal law can be decided by the Supreme Court, regardless of whether the defendant is a state or not. And even 100 years after this, many of the justices, like Justice Holmes, believe in the natural law theory of immunity. And what it means is the states are immune to the suits if the cause of action is the state law cause of action. Because you cannot sue the person who makes the law, therefore states cannot be dragged into the court if the cause of action is a state law cause of action. So the bottom line is this structural immunity, what interpretation of a structural immunity we accept, it is applicable when Congress exercises its authority pursuant to the Article 1, and definitely pursuant to the intellectual property, copyright, patent clauses. And with that, I pass the microphone to Professor Crouch.
Thanks so much, Homayun. A big thrust of the Allen decision is about this idea of Starry decisis. And this is a big ongoing debate within the Supreme Court about what level of deference the court should give to its own prior precedent. We know the court has empowered itself to change directions and reject prior precedent, but also has a history of respecting its own prior precedent. In the current court, we have an interesting setup where it tends to be the liberal justices who are now in the minority on the court. They're the ones calling for Starry decisis. It's their attempt to hold on to some of the gains that were made in the areas of such as abortion and gender and sexuality issues, for instance. In Allen, the court wrote, if patent, then copyright. And what they're meaning there is that, right, in the prior case that Homayun talked about, the Supreme Court said no sovereign immunity, the Supreme Court said we have sovereign immunity in the patent context. And then Allen was just cited essentially as if then. This linkage, as I'll talk about in a minute, was the linchpin of it in the Supreme Court's decision. In many ways had to do with the fact that both patents and copyrights are enabled within the same clause of the Constitution, right? Article 1, Section 8, Clause 8. This so-called, quote, intellectual property clause. Now, as you'll see, we kind of find this linkage between copyright and patent, at least for the sovereign immunity sense, to be lacking. Now, when you look on this slide, Homayun already mentioned the Seminole tribe case and how we have a somewhat winding road regarding sovereign immunity and exceptions to sovereign immunity. In the 1996 Seminole tribe case, the court said Commerce Clause cannot justify circumventing sovereign immunity limitations on federal jurisdiction. In that case, the court really broadly stated Article 1, that is the article granting congressional authority to make laws, that it cannot be used to circumvent sovereign immunity. That was 96. 99, the Supreme Court comes again in Florida prepaid. In that case, the court held that the patent clause of the Constitution, also found in Article 1, does not give Congress the power to override state sovereign immunity. So we have that setup. Then in 2006, the third case on my list, we get this Katz decision from 2006, and it's a divergent opinion from the Supreme Court. In Katz, the court held that Article 1 does give power to Congress to override state sovereign immunity. So essentially the opposite decision, but they say not for all of Article 1, they say in the bankruptcy clause. So the bankruptcy clause provides power to override state sovereign immunity. In that case, the court wrote that after careful study and reflection of the history, shows that the plan of the convention, that is, right, the plan of the Constitution as it was created and enacted based upon the documents available at the time, that plan of the Constitution was to abrogate state sovereign immunity in favor of a comprehensive bankruptcy system. So in Katz, the court agreed and concluded that states had agreed in the plan of the Constitution not to assert sovereign immunity in proceedings brought pursuant to the bankruptcy laws. And so what we have here is an exception, and that brings us to Allen. In our paper, we argue that the Allen court should have also conducted a careful study and reflection of the history of copyright, as it did in Katz for bankruptcy. And instead, what the court held was simply, since we already decided this in patents, we don't really need to delve further for copyrights. In our paper, we walk through the historical comparisons. And Homie, let's go ahead and reveal some of these. The basic idea is that as in bankruptcy, right, at the time of the founding, right, prior to the founding, the states had already adopted various copyright regimes prior to founding. And very early on, the US government was being petitioned for copyright protection. Then after the first Copyright Act was passed in 1790, the states rather quickly voluntarily repealed their copyright statutes. Right? Each of those elements are putting copyright in parallel to the operation of bankruptcy, and in many ways we think puts copyright in even a stronger position. If we look on the patent side, right, even after the founding and even after the first Patent Act, the states continued to offer rights to inventors on kind of an ad hoc basis as they had prior to 1788 and 89 as well. And so we don't have that same kind of transformation that we believe reflects an understanding among the states that the states were relinquishing their power over copyright and giving it over fully to the federal government. Now, actually, we think that there's some evidence for the case for that nationalizing copyright as part of the constitutional plan is even stronger than it was for bankruptcy. Notably, in the bankruptcy context, states continued to have their own bankruptcy laws and bankruptcy practice for the next 100 years following the founding. And even though in 1800 Congress did pass a Bankruptcy Act, it was then quickly repealed. And there were a few starts and stops in the bankruptcy context, but we really didn't get a real national policy for quite a long time. All of that suggesting that at least in the years immediately following the founding, there really wasn't a consensus that the nation is going to take over in the bankruptcy context. Now, I mentioned that one of the primary justifications for linking patent and copyright has to do that they're both found in the they're brethren, and that they're both found in the same constitutional clause that we all know, right? To promote the progress of science and the useful arts. The Supreme Court in Allen called this the intellectual property clause. There is this grammatical context where copyright and patent are found in the Constitution in the same location. But we argue that this grammatical kinship doesn't really prove very much. Although, right, the doctrines certainly do share some kinship. The court's reference to the, quote, intellectual property clause, we think highlights a revisionary history. Although the Supreme Court has cited this constitutional provision, Clause 8, in dozens of cases stretching back into the 19th century, it was generally in the context of discussion of the patent clause or the copyright clause or the patent and copyright clause. The court did not begin referring to anything such as an intellectual property clause until the year 2003 in the Eldred decision, right? So we're 200 years down the line before the court begins to call it that. Even the term intellectual property, the court's first use of that phrase, intellectual property within an opinion, appears to be in a tax case from 1940s. Again, right, 150 years down the line. The novelty, the newness of this term intellectual property, at least in the constitutional scope of years, we believe undermines the notion of this textual historic kinship, or at least attempts to paper over it. If you look at Article 1 further, you'll see many pairings within various clauses, right? Congress is, in one clause, Congress is empowered to coin money coupled with fixing standards of weights. Another clause says Congress establishes post office and also established post roads. It doesn't mean that those couplings have to be interpreted in identical fashion, and that a decision in one forecloses the decision in the other. And that's why, right, this is really the basis of our basic conclusion here is that Allen's algorithm, if patent, then copyright, is based upon faulty assumptions and logic.
Thank you, Dennis. So the third argument that you're pressing forward here is that the court cannot evaluate congressional record denoble. Now, as I mentioned earlier, in enactment of these statutes, Congress considered evidence suggesting that there is going to be a potential harm to intellectual property owners, copyright owners, and similarly patent owners, if the Congress would not abrogate sovereign immunity, because states are big users of, giant users of the copyrighted materials. Now, what court did is essentially saying that this record is not enough. Now, let me remind you what happened. So in Seminole Tribe, the court said Article 14th Amendment can use to abrogate sovereign immunity, but we need to have enough a clear pattern of infringement. But the court didn't articulate the test clearly. But a year later, in a case called City of Bourne, the court said that there must be some proportionality between the injury to be prevented or remedied. Now, to be prevented means potential injury, and to be remedied means actual injury. But so Congress in our opinion, could, pursuant to the city of Port, identify either potential injuries or actual injuries to the copyright owners in order to abrogate sovereign immunity. Now, although it is unfair to strike down a Congress act based on a requirement that was not there at the time Congress enacted the act, the Congress enacted this act in 1990 and the court set down the test in 1997. But Congress heard evidence that suggesting that there's going to be a lot of potential harms in future. But the court in Allen and Florida Prepaid, of course, when they didn't apply their own test correctly, they only looked for evidence of actual infringement and ignored the overwhelming evidence of potential infringement. Now, we believe that the Seventh Amendment can be interpreted to limit the fact-finding authority of the court. Because the state here is the party, court has original jurisdiction pursuant to Article 3. However, the Seventh Amendment says the court cannot do a fact-finding when something is presented to a jury. Now, Congress heard evidence. Congress analogously acted as a jury when it enacted this statute. So that's our stance. Now, the problem with the Allen case is that it also went ahead to suggest yet another test that Congress should follow in order to to abrogate sovereign immunity in a correct manner. Now, we heard from the director of the copyright that after Allen test, the Congress, Senator Leahy and Senator Tolson asked the Copyright Office to provide evidence. There is no guarantee if there is an evidence of actual infringement, the court's not come up with another test, because that's the history with this issue in the court. Now, the final topic is going to be covered by my friend Dennis.
Great. Thanks so much, Homiyoon. And I'll mention here, I see I haven't seen this yet, but Devin Hartland, who is in the audience, sent us in a link that just yesterday the district court revived or is going to take a look at the takings claims in the Allen case, and so we'll see if anything happens there. I want to talk a little bit about Starry decisis, and also we haven't really gotten into a word that's in our title called new federalism. Let's go to the next slide. So I mentioned previously this idea of Starry decisis and the liberal justices. Although, right, Starry decisis and respect for precedent, right, those are core elements of our American legal system. And as well as our traditions stemming out of England and other common law regimes. But right now, right, the Supreme Court, right, the position of the minority of liberals is really has been to promote Starry decisis in a way to hold on to some prior precedent. There's this ongoing question of how firmly do you hold on, or do you take the stance that Justice Thomas takes, is that anytime we have an error, we should make a correction. Now, at the same time, on the conservative side, we have this idea known as new federalism, and new federalism, right, can be defined a number of ways, but generally it's it's a philosophy or a movement to restore states' rights, right? So to build up the rights of states, as against the national government, and this follows both Reconstruction, but more importantly, following the New Deal earlier in the 20th century. And new federalism is generally promoted by the conservatives, although not all of them. In this case, right, we had this joining together right? The way that Dr. Rafatigiu and I see this decision as kind of outcome oriented in that, or politically motivated in a way, with the new, with the conservative New Federalists seeking the results here of sovereign immunity, stronger states' rights. And at the same time, the liberals on the court having an opportunity to again promote the idea of stare decisis, that we should hold on to the doctrine we've already decided, even if, as the case is written, if we had a clean slate, we might do it differently. We're coming to the end now on our final slide. Our basic notion here, and I think that fundamental and perhaps even more fundamental than stare decisis, is this general idea that if someone has a right, there should be a remedy. We have, in some sense, this question asked by Chief Justice Marshall in Marbury versus Madison, and answered in that case as well. Yes, the laws do afford some kind of remedy and should, and we have this potential seemingly real gaping hole in the copyright regime, as well as the patent regime, where we have a potential for ever-growing state governments, state entities, to essentially be able to move forward without any regard to individual copyrights.